Hey, Jeffo Crime Nerds, we are going to just dive into the sentencing memo that Bloodworth, the prosecutor in the Kouri Richins case, submitted the day before sentencing. That was public. These don't always come out publicly, but this was a fascinating one and has information that has never come out before. Some of it was mentioned in the actual sentencing hearing, some of it was not, and it's powerful stuff, some heartbreaking stuff. So I'm just going to read it, and I'll put it on screener so you can see it as well if you want to zoom in. The case of Kouri Richins, who has now been convicted and sentenced for offing her husband in 2022. So it lists all of the prosecutors involved, but the wording is such you can tell it's Bloodworth. It's his voice for sure, especially when he talks about that Kouri being aggrieved. He used that exact phrase in his closing argument. So here's what it says. This is on page 1, just starting after all that intro stuff, the first paragraph. On Valentine's Day 2022, Kouri Richins tried and failed to murder her husband and the father of her 3 young children, Eric Richins. Over the next 17 days, she did not think, well, what have I done? Rather, she thought, how can I do better? And then she murdered Eric in the presence of their children using poison and for money. Such a person should never again lurk among the rest of us. He is such a good writer. Dang. Her children should never worry that they may one day encounter her. Accordingly, the state requests that the court impose a sentence of life in prison without parole. Kouri Richins has earned it. Yes, she has. Her children deserve it. Only this court can order it. Okay, so the second page here is that's the state sentencing request. It goes 1 through 8, all the different counts. I'll skip over that. That's not the interesting part. On page 3, here we get to the argument. When sentencing, the court is to weigh and consider public safety, punishment, deterrence, incapacitation, restitution, and rehabilitation. For consecutive versus concurrent sentencing decisions, the court must consider the gravity and circumstances of the offenses, the number of victims, and the history, character, and rehabilitative needs of the defendant. Quote, a sentence in a criminal case should be appropriate for the defendant in light of his background and the crime committed, and also serve the interests of the society which underlie the criminal justice system. So all those are quotes from various cases. The court is to examine both aggravating and mitigating factors to include the nature and circumstances of the crime, the defendant's character, background, history, and mental and physical condition, the impact of the crime on the victim's family and community, and any other facts in aggravation or mitigation of the penalty. Not all aggravating and mitigating factors are equally important, and, quote, one factor in mitigation or aggravation may weigh more than several factors on the opposite scale, unquote. A few egregious aggravating factors may outweigh several mitigating circumstances claimed by the defendant. The, quote, psychological reality is that aggravating circumstances in first-degree murder cases, quote, will virtually always outweigh or be more compelling than the mitigating circumstances, unquote, because, quote, the commission of a capital homicide, i.e. an intentional murder, is one of the most heinous acts known to society, unquote. The sheer emotional impact of all the evidence of an unjustified killing tends to overwhelm evidence of mitigating factors in the mind of the sentencing authority. The court is to consider the totality of the circumstances in imposing a sentence that is proportionate to the crime and the culpability of the defendant. The court is not limited to the circumstances of the crimes to which the defendant has been convicted, but may consider other factors as well. And he will list them. Evidence that is inadmissible at the guilt stage may be admissible for the purposes of sentencing. Such information must be reasonable, reliable, and relevant. Here, the state took the death penalty off the table in the early days of the case, and I've been curious as to why. Someone knows? Please enlighten me. Accordingly, on count 1, the court must sentence the defendant to either LWOP without parole or an indeterminate term of imprisonment for 25 years to life. There is no presumption in favor of either of the two sentencing options. In totality, the egregious aggravators outweigh the perfunctory mitigators and require a sentence of life without parole on count 1 and consecutive sentencing on the remaining counts. In 1, the court should sentence a defendant to life without parole on count 1. A, the nature and circumstances of the crime are irrational. The defendant murdered her husband in the presence of their young children using a poison for money, and after trying and failing to murder him 17 days earlier. The Utah legislature recognizes that homicidal poisoning and murder for money are each so heinous as to individually warrant the death penalty. Here, the jury found the defendant guilty of both aggravators. The defendant chose poison. Jurists throughout the time have recognized the particularly heinous nature of homicidal poisoning. Of all species of death, the most detestable is that of poison, because it can, of all others, be the least prevented by either manhood or forethought. The Florida Supreme Court has called poisoning a conscienceless, pitiless crime. The California Supreme Court observed a murder carried out by deliberately giving the victim poison is more cruel and aggravated than other malicious or intentional killings, both because such a killing involves preparation and planning, and because the killer intentionally deprives the victim of any chance of escape or self-defense. The poisoner acts surreptitiously, thus avoiding detection, often betraying the most intimate trust. Here, the defendant betrayed the most intimate trust of her husband and her children. Well, side note here, the idea that poisoning is the most heinous, or one of the most heinous ways of doing this, does bother me a tad, simply because I think things like torture and those kinds of things are far worse. And also because it feels kind of misogynistic, because poisoning tends to be the weapon of choice of female killers. I think, I'm sorry, the beating and violence and whatnot is worse. I don't know. I'm not to rank the big M variations, but the idea that so many people think that the poisoning specifically is so much worse than some other things. I think some victims of other crimes would beg to differ, but okay. Continuing. The defendant decided that Eric Richins' money was worth more than his life. Courts have consistently recognized that spousal murders motivated by money are especially egregious. In one case, the Arizona Supreme Court observed killing in this case did not arise out of heat of passion, fear, struggle, or attempt to escape. This killing was not just the result of momentary premeditation, but of defendant's deliberate, carefully conceived, meticulously planned, and cold-blooded scheme to kill rather than divorce his unsuspecting wife. The New Jersey Supreme Court observed these killings do not stem from some powerful visceral emotion, but rather from greed and expedience. Furthermore, few crimes display a more callous disregard for human life than the premeditated decision to seek profit by way of homicide. It evidences an abandonment of all of the rules of society that is constructed to maintain communal life and warrants the fullest condemnation and retribution. The impact on the victim's family is irreparable. Fathers are not meant to bury sons. And losing a sibling is losing a piece of yourself. So Bloodworth used this in part of his statement on sentencing day as well. That's this part. But there are no greater victims in this case than Eric's 3 young boys. The defendant took both of their parents from them. The aggravated was a crime of domestic in the presence of children. Eric Richins was a good husband. He cared and provided for his wife and even protected her from herself. Eric was a good father. He knew that the defendant tried to murder him on Valentine's Day, and he also knew that it was unsafe for his children if he were to leave the home. Eric died protecting his boys, and they know it. That last bit, they know it, is a big part to me, a big aggravating factor. CR, of course, we're referring to the boys by their initials, was 9 years old when his mother murdered his father. He is now 13 and wears his father's clothes to school. That breaks my heart. Following Eric's death, DCFS supported a finding of emotional and physical by defendant against CR. Yeah, and if you watch my video about the children's statements, we hear some of that. Yeah. He and his brothers have participated in intense therapy since the defendant was arrested 3 years ago. CR wants the court to know that, quote, my dad was a good person and very thoughtful and kind and helped whoever needed help. And that, quote, I'm afraid if she gets out, she'll come after me and my brothers, my whole family. I think she would come and take us and not do good things to us, like hurt us. I miss my dad, but I do not miss how my life used to be. I don't miss Kouri. I will tell you that. Heartbreaking. And I've heard this a few times now, this statement, and I'm reading it again. Something else just hit me this time. That she'll come after me, my brothers, and my whole family. He's meaning Katie and Clint and his cousins and Amy and her husband and his grandparents. He's referring to all of them, but not Kouri. She's not family anymore. AR was 3 weeks shy of his 8th birthday when his mother murdered his father. The defendant made AR her alibi, thereby condemning her child to be a material witness. And that was something, when I first heard the statement, that hit me so hard. It hadn't occurred to me that she hadn't at least at some point gone in to see her son. But he was like, no, she wasn't there. She didn't come into my room, but she claimed she did. He told the police as much at the time, but later said, no, she didn't. She wasn't in my room that night. If called to testify at trial, AR would have recalled being put to bed early on March 3rd, 2022, without bathing, which was unusual for the boys. The television was playing loudly inside his parents' bedroom, and when AR tried to enter, he found he was locked out. AR used a broom to try to dislodge a key from above the door frame, intending to unlock the door and enter the bedroom. AR accidentally hit the wall with a broom, making a noise that attracted his mother's attention. She yelled at AR to go away. She later entered his room and asked him what he needed. AR pretended to be asleep because he was angry with her. Later during the night, his younger brother, WR, woke and tried to enter his parents' bedroom to sleep with them, as was his habit. WR also found himself locked out and slept in AR's bed. So the two boys were together. She wasn't with them. And she kept them out of the room, even though she knew that the boys sometimes came in if they were scared or something. And again, the idea that she used her middle son as her alibi. Oh my gosh, no wonder this kid's I'm so glad they're in therapy, because holy cow, that would mess with your head. WRC also found himself locked out and slept in AR's bed instead. AR would have testified at trial that the defendant did not sleep in his room with him the night she murdered his father, which I think, thank heavens he did not bring them to the stand. He could have, and just completely trashed Kouri's story, but that would have been so damaging. So I think Bloodworth, the rest of the prosecutorial team, must have been so confident they could get a conviction that they spared the boys that trauma. So well done, dudes. Everybody on that team, good job, because these boys are traumatized enough. AR wants the court to know that my dad can't be my coach anymore and can't be at any of my games. He won't be at my birthdays. He can't teach me how to drive. He won't be at my graduation, and he can't take me camping or fishing. Keep in mind, this kid is like, what, 10 or 11 now? Somewhere in there. And he's already thinking ahead to his graduation. And he can't take me camping and fishing. Those are things he probably did a lot with his dad. I don't want the defendant out of jail because I will not feel safe as she is out. With her in jail, I will be able to continue to feel safe and live happy and a successful life without fear of her hurting me or anyone I love. Hurting me or anyone I love. Meaning he doesn't love her. That would destroy me as a mother, but it doesn't her. Clearly, when you see some of these statements being read in court, she's just like, what? Oh, can't believe they would say this. But she doesn't look hurt or devastated that her children would say these things about her, which means A, they're true, and B, she has no heart. And also tells me that Katie and Clint and the rest of the Richins family has done a good job of making sure these boys know that they are loved and that the boys love them in return. So good job, guys. WR was still in preschool when his mother murdered his father. He has now lived half his life without his father and 3 years without his mother. His memories of both are limited. He remembers being scared the night of his father's murder and wetting his pants while held in the bedroom before his Aunt Katie arrived. WR wants the court to know that when someone talks about Kouri, it makes me feel hateful and ashamed. She took away my dad. And that if she got out, I would be so scared. I'm worried that she would take me away. Once she is gone, I will feel happy and I will feel safer and relax and trust people more. If the defendant serves 25 years in prison, she could potentially be paroled at age 57. So the judge did say it most likely would be like 66, but technically potentially at 57, which is so young for something like that. Her sons will be 36, 35, and 30, and likely will have their own families. The boys deserve finality and should not have to revisit their father's murder at future hearings or worry about the defendant's potential parole. Given the tremendous trauma and upheaval that the defendants inflicted upon their childhood, this court should ensure that she does not harm their adulthood. Not only should the defendant serve her life in prison, but she should serve her boys' lives in prison. This is best closure her children can hope for. Only this court can give it to them. And I'm doing the math now. I'm realizing that her two boys, oldest boys, are really close in age. So if the oldest is now 13, the youngest is probably now 12 or close to it. Katie and Clint are now raising 3 boys that require extraordinary love, support, and stability. It is best for the boys, and everyone is thriving. But Katie and Clint never planned for it. Katie never planned to administer an estate or a trust or tackle vindictive litigation. Gene, this is the father of the Richins family, so Eric's dad, Gene never planned to work the family ranch at his age without Eric. Katie and Amy both live with guilt for not doing more to protect their brother from his wife, which, as I've said in another video, totally not their fault, but I understand that even intellectually they could know that it's not their fault, but feelings aren't logical. The aggravated impact extends beyond Eric Richins' family. Josh Grossman, that's the boyfriend that she had an affair with, bears the weight of knowing that he contributed to the defendant's motivation to murder Eric. It has gutted him. We saw that on the stand. Chelsea Barney bears similar weight, knowing that the defendant murdered Eric in some measure to salvage Ms. Barney's life savings. And in the process, she lost her home anyway. It haunts Carmen Lauber that she unknowingly provided the defendant with the fatal drug. Cody Wright and Josh Case question whether they could have done more to save their friend. And of course, the answer is no, because Kouri would have found a way, as evil as she is. C, the defendant's character is irredeemable. The defendant is transparent. Evidence of her character is well known from all stages of this proceeding, including her prioritizing a facade of success over everything.
Kouri Richins is intensely ambitious.
Her fraudulent borrowing, her stealing her best friend's life-saving, her persistence in murdering Eric after failing on Valentine's Day, her self-publishing a children's book for money and attention, and the aim of her walk the dog letter, among a slew of other examples. The defendant cannot check her ambition.
Kouri Richins is intensely ambitious.
Or her sense of entitlement. When confronted, she lies. When she feels aggrieved, she attacks. And she certainly feels aggrieved. She always has. In the immediate aftermath of the guilty verdict, the defendant blamed a corrupt prosecution, a corrupt judge, and unfair Summit County jurors. 6 weeks following the guilty verdict, the defendant texted an admirer. I will never understand why people in jail and prison have admirers who contact them, but whatever. This shows her complete lack of remorse. She said, this is in the text, I will, that's all caps, expose this county, the prosecution, the judge, the Richins, the investigation, all of it. So they can lock me away for now. That's fine. It's going to come back on them. It will come to an end. Not this year or next, but I'm not going away. I won't be silent. I am going to expose them all for what they have done to me, my kids, my family. This injustice. They picked the wrong one. They think that sentencing is, quote, the end, quote, closure. It is just the beginning. They haven't seen anything yet. Winky emoji. And because I'm petty, I'm going to do a copy edit on that. Most telling of her character, the defendant attacked Eric. Within hours of her arrest, she, for the first time, blamed Eric for his own death.
No!
From jail, the defendant and her family engaged in, quote, open season on, quote, Eric the Dead, releasing what they believed to be damaging information about Eric to the media. During the trial, the defendant falsely accused Eric of having an affair with a coworker and a homosexual affair with one of his best friends. The Richins' children are familiar with the inescapable media coverage of this case. Many of the defendant's attacks against the Richins family permeate the record. For example, she throat punched Amy Richins 2 days after murdering Eric when Amy informed her of the Eric Richins Living Trust. Eric created the trust to protect her and their children. 4 days later, she hired counsel to breach the trust. She told Jean Richins that Eric died of the same lung mold that killed Jean's wife. Cruel. Just cruel, period. Full sentence. Love it. It's heinous. Absolutely true. Absolutely cruel. In the walk the dog letter, the defendant instructed her mother to release photographs of Katie's young children to the media and wrote, quote, bring me home and then we'll get those DBs. When confronted with the letter, the defendant insisted in the face of all reason that it was part of a, quote, freaking book, a half-true, half-fiction novel about her incarceration.
Sure, Jan.
Other of the defendant's attacks against the Richins family are new to the record. For example, when the estate's investigator found bank statements with Kouri Richins' Realty's account header and C&E's account details, the defendant accused Katie and hired counsel to advocate for the criminal prosecution of Katie. While detained pre-trial, she caused her family members to pursue federal firearms charges against Jean for removing Eric's firearms from the Willow Court home for safekeeping, file false reports with DCFS against Katie, and report Amy Richins to the police for marijuana possession.
Loser.
To this day, the defendant maintains insurance policies on the lives of her children. Now, the defense claimed on sentencing day that she didn't know they were still active, and if it helps to help with anything, then she'll cancel them now. Whatever. The Richins family will not be safe if the defendant is ever paroled. The defendant's attacks extend beyond the Richins. While detained pre-trial, the defendant caused her family members to file unfounded bar complaints against the Summit County attorney and chief prosecutor and post a gay dating profile of the lead detective online. The first time we've heard of that, the defense denied it. Of course they did. The defendant also made an unfounded criminal complaint to the FBI about Eric Richins' business partner. Are you kidding me? She just never ends. It just never stops for her. The defendant's character is evident despite her well-crafted facade. Eric surviving Valentine's Day, 3 years of pretrial detention, and a resounding guilty verdict has only amplified the worst of her character.
Kouri Richins is intensely ambitious.
It did not remedy it. She has expressed no remorse and has indeed publicized the opposite. The irrational nature and circumstance of the aggravated murder is irreparable impact on the Richins family and others, and the defendant's irredeemable character prove overpowering aggravation. Any mitigation the defendant presents will only be more facade. It is all she has. Yep. But even if credited, it cannot outweigh the aggravation. Accordingly, the defendant has earned the maximum punishment short of death, and public safety requires her permanent incapacitation. She has well established that her rehabilitation is beneath her. Life without parole, combined with the intense publicity cultivated by the defendant and her counsel, will also deter would-be poisoners from coldly murdering their spouse and their child's parent. 2. The court should sentence consecutively on counts 2 through 5. The gravity of the attempted aggravated murder is that the defendant learned from her mistakes. She had learned to obtain, quote, something stronger and to administer it in a way that prevented Eric from realizing the poison's effects until it was too late. The circumstances of the attempted aggravated murder are identical to the circumstances of the murder. It was in a sandwich. He tasted, took a couple bites, felt sick, didn't eat the whole sandwich. And of course, when she succeeded, it was in a shot. So he knocked it back, swallowed it. If he tasted something bitter, too late, it's already in the system, and he didn't know. So yeah, she learned. The gravity and circumstances of the frauds and forgery punch above the charge's weight because they encompass the defendant's motive for murdering Eric and the pecuniary gain aggravator. The defendant's character, as discussed, is irredeemable. Accordingly, the defendant earned distinctive punishment for counts 2 through 5, and the court should sentence them consecutive to any other sentence, meaning they wouldn't happen at the same time. She would serve one and then the next and the next. 3. The court should enter a continuous protective order in favor of Eric Richins' family members. The defendant was convicted of domestic violence, aggravated murder, and attempted aggravated murder. Utah's Criminal Protective Order statute provides that when a perpetrator is convicted of a domestic violence resulting in a sentence of imprisonment, that is to be served after conviction. The court shall issue a continuous protective order at the time of sentencing, limiting the contact between the perpetrator and the victims unless, 1, the court determines by clear and convincing evidence that the victim does not have a reasonable fear of future harm or abuse. Protection may include any order, quote, the court considered necessary to fully protect the victim, and this is in italics and bolded, and the members of the victim's family. Here, Eric Richins is the only quote-unquote victim under Utah's crime victims statute. Paradoxically, Eric Richins' family members, including his children, are not quote-unquote victims. It is evident that Eric Richins does not have a reasonable fear of future harm or abuse, which is the Criminal Protective Order statute's threshold inquiry. Thus, the Criminal Protective Order statute yields the absurd result that the family members of domestic violence murder victim are left unprotected when family members of all other domestic violence crimes can be protected. This is where the absurdity doctrine comes into play. Courts will apply the absurdity doctrine when, quote, the operation of the plain language is so overwhelmingly absurd that no rational legislator could have intended the statute to operate in such a manner. This standard is satisfied only if the legislature could not reasonably have intended the result. Applying the absurdity doctrine to this subsection of Utah's Criminal Protective Order statute, this standard is satisfied here. Clearly, the legislature could not have reasonably intended to accept the family members of domestic victims from protection. The defendant's conduct and the victim impact statements firmly establish that it is necessary for the court to protect CR, AR, and WR from their mother, as well as Eric's father and his sisters and their families. Anyone can appreciate the family's fear resulting from the defendant maintaining insurance on the boys' lives. Accordingly, the court should issue a continuous protective order that prohibits the defendant from contacting Eric Richins' family members unless they first initiate contact, and prohibits her from maintaining or benefiting from insurance on the lives of CR, AR, and WR. Interestingly enough, the judge ruled that he couldn't, based on the statute, he did not agree that the absurdity doctrine qualified and so he couldn't do the protective order, which I think because of the Gavin Peterson case, also in Utah, that I think that I beg to differ. I don't know how that's different because that judge, Camille Nider, did do a protective order against the other children. But he did, of course, now we know, he says sentenced her to life without parole. So, and in part, in his argument explaining it, was to protect those boys. So I think that this is the best he could do in his mind. 4, the court should order the defendant to pay restitution. Utah's Crime Victims Restitution Act requires district courts to determine restitution for any pecuniary damages approximately caused by a defendant's criminal conduct. Insurance companies are victims under the statutory definition. Additionally, the defendant is a quote-unquote killer within the meaning of Utah's so-called Slayer statute, which provides that a wrongful acquisition of property or interest by one who kills another shall be treated in accordance with the principle that a killer cannot profit from the killer's wrong. People refer to those kinds of laws as Slayer laws or as Son of Sam laws. Someone that can't write a book about their story and then benefit from it, or whatever else. The defendant received $1,017,018.49 from Auto Owners Insurance Company and $352,562.61 from True Stage Insurance Company as the beneficiary of insurance on Eric's life. These insurance companies paid out as a result of the defendant committing aggravated as convicted in count 1. Moreover, True Stage paid out because the defendant committed insurance fraud and forgery as charged in counts 3 through 5. Accordingly, the court should order the defendant to pay restitution to Auto Owners Insurance Company in the amount of and True State Insurance Company and the other amount. 5, the court should order the defendant to pay recoupment to Summit County. After Ray, Quinney, and Nebeker abruptly withdrew from this case in May 2024, the court declined to require the defendant to complete an affidavit of indigency, citing the Fifth Amendment concerns. Order appointing indigent counsel. The court found that the defendant was indigent on the sole basis of former counsel's representation that the defendant does not have access to financial resources sufficient to retain private counsel. Summit County thus became statutorily obligated to provide defense services to the defendant. And she had 3 huge, big name, successful defense attorneys, like Kathy Nestor, Wendy Lewis, and Alex Ramos. That's a big team, more than she probably constitutionally needed. The cost of these services will exceed $1.3 million. If the court learns that an individual provided with indigent defense services is in fact not indigent, the court shall order that individual to pay the indigent defense system the cost of services. And shall is in italics because in legal documents, shall means that this needs to happen. It's not optional. The defendant continues to litigate claims to Eric's premarital home and share of the trust. To the extent any of these assets or any other assets are adjudicated to the defendant's property, the court must order the $1.391 million of those assets paid to Summit County as recoupment for indigent defense services. Additionally, the court may order a defendant to pay costs or expenses incurred by a political subdivision of the state for attorney fees of counsel assigned to represent the defendant. To the extent that the defendant or her representatives or assignees receive any money that is not subject to the Prop from Notorious Criminal Activity Act, the court should order the $1.391 million of that money to be paid to Summit County as recoupment for indigent defense services. Conclusion, the court should sentence the defendant to life without parole among the state's other sentencing requests. The sentence is appropriate considering the crime she committed, their impact on her children and Eric Richins' family, and her irredeemable character. This sentence serves the interests of society underlie the criminal justice system. Most importantly, no other sentence can provide CR, AR, and WR the comfort and protection that they need and deserve. Dated May 11th, 2026, and then it's signed Brad Woodworth. Certificate of service, I hereby certify that on the 11th day of May, 2026, that I e-filed a true and correct copy of the state sentencing memorandum for the above case, which served all counsel. That's the sentencing memorandum. And some of my thoughts on it. Let me know what you think. And not only of the memorandum, but also the sentencing hearing itself. I'd love to hear your thoughts. Like, follow, subscribe, all the things, share with your friends. Let me know what you think. I'll see you in the next one.